Law and Justice, the fifth topic of the Indian book yearbook and summary. Ministry of Law and Justice is the oldest limb of Government of India dating back to 1833 when the Charter Act of 1833 was enacted by the British Parliament. By virtue of this authority and the authority vested under him, Section 2020 of the Indian Council Act 1861, the Governor General in Council enacted laws for the country from 1834 to 1920. There was Government of India Act 1919. The legislative power was exercised by the Indian legislature constituent thereunder. The Government of India Act 1919 was followed by the Government of India Act 1935. India became a dominion and the Dominion legislature made laws from 1947 to 1949 under the provision of Section 100 of the Government of India Act 1935 as adapted by the Provisional Constitutional Order 1947. Ministry of Law and Justice comprises the three departments, namely Department of Legal Affairs, the Legislative Department, and the Department of Justice. National Mission for Justice Delivery and Legal Reforms. National Mission for Justice Delivery and Legal Reforms was set up in 2011 with a twin objective of increasing access by reducing delays and arrears in the system and enhancing accountability through structural changes and by setting performance standards and capacities. The mission has been pursuing a coordinated approach for phased liquidation of arrears and pendency in judicial administration, which inter alia involves better infrastructure for courts, including computerization, increase in strength of subordinate judiciary policy, legislative measures in the areas prone to excessive litigation, re-engineering of court procedures for quick disposal of cases, and emphasis on human resource development. The criteria of judge population ratio for determining the adequacy of the judge strength in the court country has been reviewed by the Law Commission in its 24th report 2014 prepared on the direction of the Supreme Court in this case. In this report, Law Commission has observed that filing of cases per capita varies substantially across the geographic unit as filings are associated with the economic and the social condition of the population. As such, the Law Commission did not consider the judge population ratio to be scientific criterion for determining the adequacy of the judge strength in the country. In August 2014, the Supreme Court asked the National Court Management System Committee to examine the recommendation made by the Law Commissions to furnish their recommendation in this regard. The National Court Management System, in its reports to the Supreme Court in March 2016, it has inter alia observed that in the long term, the judge's strength of the subordinate courts will have to be assessed by a scientific method to define the total number of judicial hours required for disposing of the case load of each court. In the interim, this committee has proposed a weighted disposal approach, disposal weighted by the nature and the complexity of the case in local conditions. Judicial infrastructure. Until 2011, the central and the state government used to contribute equal share of the scheme, but from 2011 to 12 onwards, the central government was contributing 75% of the fund. In case of the northeastern state, central government provided 90% fund of the fund. Central funding is, however, subject to budgetary allocation for the scheme. E-Court Integrated Mission Made Promote Project. The E-Court Integrated Mission Made Project is one of the e-government projects being implemented in the high courts and district subordinate courts of the country. The project had been has been conceptualized on the basis of the national policy and the action plan for implementation of the information and communication technology in the Indian judiciary 2005 by the E-Committee of the Supreme Court of India. National litigation policy. Government is said to be the major litigant, and there have been several law commission reports suggesting for litigation policies to avoid unwarranted litigation by the government and thus bring down load on the court system as well as burden on the public exchequer. Therefore, the draft National Litigation Policy 2017 proposes to put in place system which prevents, control and reduces litigation. Appellate Tribunal for Foreign Exchange. The Appellate Tribunal for Foreign Exchange was established in 2000 under Section 18 of Foreign Exchange Management Act 1919. Under Section 19 of FEMA, the central government or any person aggrieved by an order made by special director appeals or made an adjudicating authority other than referred into subsection 1, Section 17 may prefer an appeal to the appellate tribunal that may be filed within 45 days of the date of receiving the order by the aggrieved person or the central government. Enforcing agencies. All senior police posts in various states are manned by the Indian Police Services cadres, recruitment to which is made on all India basis. Central government maintains Central Police Forces Intelligence Bureau, Central Bureau of Investigation Institution for training police officers and forensic science institution to assist these states in gathering intelligence and maintaining law and order and investigating special crime cases and providing training to senior police. Indo-Tibetan border. Indo-Tibetan border police is basically a mountain trained force and most of the officers and men are professionally trained mountaineers and skiers. ITBP mountaineers have also been successfully climbed peaks in Nepal, Iran, Japan, South America. ITBP skiers have also been national champions and have taken part in Winter Olympics. They have also participated in adventurous white water rafting through turbulent and mighty waters in the Brahmaputra, the Indus, and the Ganges, and have also international achievements to be created in this field. Border security force role during the peace time is as follows: to promote a sense of security among the people living in the border areas, to prevent trans-border crimes, unauthorized entry into or exit from territory of India, to prevent smuggling of any illegal activities on the border, anti-infiltration duties, to collect trans-border intelligence. Its role during the wartime is as follows: holding grounds in assigned sector, limited aggressive action against the central armed police or irregular forces of the enemy, maintenance of law and order in enemy territory, administrative under the army's control, guarding of prison of war camps, acting as guide to the army in border areas, assistance and control of refugees, provision of sectors, and performing special tasks connected with the intelligence, including raids. Assam Rifle. The Assam Rifle contributes towards assimilation of the people of the Northeast in national mainstream is truly monumental. The long association of this region reflects into being fondly called the Sentinel of the Northeast, friend of the hill people, and friend of the people security in the Northeast region and guarding the Indo-Myanmar border. National Security Guard, especially equipped trained forces like SAS of UK, Delta Force of USA, and GSG-9 of the West Germany were raised abroad. The need of creating a special force for executing surgical operations based on tactical intelligence was felt in India when Operation Blue Star was carried out with the army at Golden Temple, Amritsar in 1984. National Security Guard was conceptualized and created after studying and analyzing special forces like SAS in the United Kingdom and GIGN in France, GSG in Germany, Sharat-e Maktal in Israel, and Delta Force in USA. Sahastra Seema Bal is guarding Indo-Nepal border since 2001 and have also been given an additional report or responsibility of guarding Indo-Bhutan border since 2004. Its earlier aim was to build people's moral and inculcate a spirit of resistance in border population in them, the North in them, then Nepal, North Assam, North Bengal, hills of Uttar Pradesh, Himachal, and Jammu and Kashmir. The area of operation was extended to other borders as Manipur, Tripura, Jammu and Meghalaya, Sikkim, Rajasthan, Gujarat, Mizoram, South Bengal, Nagaland between 1965 to 91. The role of SSB in earlier setup includes to inculcate a sense of security and spirit of resistance in border population, promoting national awareness and security consciousness, and organizing preparing border populations to resist enemy. Civil Defense Act. The Civil Defense Act 1968 was suitably amended by Civil Defense Amendment Act 2009 in 2010 to include a disaster management as an additional role for the Civil Defense Corps while retaining its primary role. Although Civil Defense Act 1968 is applicable throughout the country, the organization is only raised in such areas and zones where tactically and strategically considered vulnerable from enemy's attack point of view. Home Guard is a voluntary force first raised in India in December 1946 to assist the police in controlling civil disturbances and communal rights. Home Guards are also raised under the Home Guards Act and rules of the states, union territories. They are recruited from various cross sections of the people such as doctors, engineers, lawyers, private sector organizations, college and university students, agriculture and industrial workers, etc. The Ministry of Home Affairs formulate the policy in respect of role, target, raising, training, equipping, establishment and other important matters of Home Guards organization. Expenditure on Home Guard is generally shared between center and the state governments as per existing financial policies. Personal law. They are governed by different set of personal laws in respect of matter relating to family affairs, marriages, divorce, succession, adoption, wills, etc. The subject matter of the personal law is relatable to the entity 5 list 3 of concurrent list in the 7th schedule of the Constitution of India. Hence, the Union Legislature, namely Parliament, is the subject provision of Article 254 of the Constitution. The state legislature are also competent to make laws in the field. Marriage. The Special Marriage Act 1954, which provides a special term of marriage and the registration of such marriages extends to the whole of India except for the former Jammu and Kashmir, but also applies to a citizen of Indian domiciled in Jammu and Kashmir. Persons governed by this act can specifically register marriage under the said act, even though they are of different religions, faith. Section 33 and 38 have been amended to provide the application for alimony or maintenance and education of minor children to be disposed within 60 days of the date of the service of notice on the respondent. An attempt has been made to codify customary laws which prevent among Hindus by enacting Hindu Marriage Act of 1955, which act has an extent to the whole of India except the former Jammu and Kashmir, applies to also the Hindu domiciled in the territory into which act stands and to those who are outside of the said territory. It applies to the Hindu in its form of or development, also to the Buddhists, Sikhs, Jains, and also to those who are not Muslim, Christian, Parsis, or Jewish by religion. However, that does not apply to the member of any scheduled tribes unless the central government by notification in the official gazette otherwise. Provision as regard to divorce are contained in the section 13 of the Hindu Marriage Act and section 27, the Special Marriage Act. Common grounds which can divorce be sought by a husband or a wife under these acts: adultery, desertion, cruelty, unsoundness of mind, venereal diseases, leprosy, mutual consent, and being not heard of as alive for 7 years. In the Divorce Act 1869, comprehensive amendments were made through the Indian Divorce Amendment Act 2001 to remove discriminatory provision against women in the matter of divorce and to provide dissolution of marriage by mutual consent. Further, Section 41 of the Indian 1869 Act was amended by the Marriage Law Amendment Act 2001 to provide an application for alimony or maintenance of the education of minor children be disposed of within 60 days from the date of service of the notice on the respondent. Adoption. Although there is no general governing adoption is permitted, the Hindu Adoption and the Maintenance Act 1956 amongst Hindus by the customs and among few numerically insignificant category of persons. Since adoption is legal affiliation as a child, it forms subject matter of personal law. Muslims and Christian Parsis have no adoption laws and they have to approach the court under the Guardians and the Ward Act 1819. Muslims, Christians, and Parsis can take child under the said act only under the foster care. Once child under foster care attains the age of majority, that is 18-year-old, he is free to break away all these connections. Besides, such child does not have any legal right of inheritance. Foreigners who want to adopt Indian children have to approach the court under the aforesaid act. Maintenance. Under the Code of Criminal Procedure 1973, right of maintenance extend not only to the wife and dependent children but also to the indigent parents and divorced wife. Claims of the wife, etc., however, depends on the husband having sufficient means. Under the Hindu law, the wife has an absolute right to claim maintenance from her husband, but she loses the right if she deviates from her path of chastity. Her rights to maintenance is codified in the Hindu Adoption and Maintenance Act 1956. The Personal Amendment Act 2019 further amended to the Divorce Act 1869 4 of 1869, the Resolution of Muslim Marriages Act 1939 8 of 1939, Special Marriages Act 1954, the Hindu Marriages Act 1955, and the Hindu Adoption and Maintenance Act 1950, so as to omit the provisions that are discriminatory to the leprosy affected person contained therein. The Amendment Act came into force on March 1, 2019. The Muslim Protection of Rights on Marriage Bill 2019, which replaced the Muslim Women Protection Rights of Marriages Second Ordinance 2019, was enacted as Act 20 of 2019 on July 31, 2019. The enactment is for prevention of divorce by the way of talaq-e-biddat by certain Muslim husbands in spite of the same having been set by the Supreme Court. This act is in force from September 19, 2018, that is from the date of the first order, namely the Muslim Women Protection of Rights on Marriages Ordinance 2018. The Parsi Marriage and Divorce Act 1936 reorganizes the right of wife to maintenance, both alimony and the permanent alimony. The maximum amount that can be decreed by the court as an alimony during a time at a matrimonial suit is pending in the court. 1/5 of the husband's net income. The Divorce Act 1869 governs maintenance rights of a Christian wife. The provision of same as under the Parsi laws and considered are applicable under granting maintenance, both alimony and permanent maintenance. Election laws and electoral reforms. The acts in connection with the conduct of election to parliamentary, state legislature, and to the offices of the president and vice president are the Representation of People Act 1915, the Representation of People Act 1951, the Presidential and the Vice Presidential Election Act 1952, the Delimitation Act 2002, the Andhra Pradesh Legislative Council Act 2005, and the Tamil Nadu Legislative Council Act 2010. These are administered by Legislative Department, Ministry of Law and Justice. Delimitation of constituencies. The periodic readjustment of Lok Sabha and Assembly constituency is mandatory in representative system where a single member constituency are used for electing political representative. The electoral boundary are drawn on the basis of the last published census figures and are relatively equal in population. Equally populous constituency allow voter to have an equally weighted vote in the legislature. Electoral constituency that are very greatly in population are called conditions malappropriation violates a central tenet of the democracy, namely all voters should be able to cast a vote of equal weight. Delimitation and elections are two basic pillars of the parliamentary democracy. The first delimitation commission in India was constituted in 1952, the second in 1962, and the third in 1973. The third delimitation exercise based on 1971 census was completed in the year 1975. The present delimitation based on census 2001 has been undertaken after 30 years. The population increased by almost 87% and the nature of the constituency in the country by and large have become mal apportioned. Although the rules for delimitation vary across the country, tasks involved in drawing boundaries are generally similar in India. Drawing of boundaries generally entails allocating seats to the state and district within the state, creating a database composed of maps, population figures, and the details showing geographic, natural, administrative conditions of the area concerned, associating these statutory representatives from the Lok Sabha, the state assemblies, distributing the states and the district into geographic units called constituencies, having an extensive exercise for public inputs into delimitation processes, summarizing and evaluating the constituencies and passing and publishing the final order. The procedure of delimiting the constituency in India stands clearly spelled out in the Delimitation Act 2002. With the issuance of the presidential order specifying the date on which delimitation orders notified by the Delimitation Commission shall take effect, it was necessary to amend the relevant provision in first and the second schedule of the Representative of the People's Act 1915 to reflect the changes made by the delimitation order notified by Delimitation Commission as consequential requirement. The Representation of People Amendment Act 2008, amending the Representation of People Act 1915 in conformity with the Delimitation Act, was enacted and made effective from 2008. By this amendment act, the first schedule and the second schedule of the Representation of the People Act 1915 were replaced during the other amendments. Further, a new section 8A was inserted in the Representation of People Act 1915, which provided that if President of India is satisfied that the situation of the condition prevailing in Arunachal Pradesh, Assam, Manipur, Nagaland are conducive for the conduct of the delimitation exercise, he may, by order, rescind the said deferment order issued under the section 10A of the delimitation of 2002 in relation to any of these states and provide conduct for delimitation exercise in the state by the Election Commission of India. Electronic voting machines. The use of electronic voting machine was started in the country on experiment basis and it took more than 2 decades for the universal use of EVMs, and during elections to Lok Sabha in 2004, EVMs were used in all polling stations across the country. The EVMs were developed on the behest of Election Commission jointly with two public sector undertakings, Bharat Electronics Limited BEL Bengaluru, Electronic Corporation of India ECIL Hyderabad in 1989. Voting rights to the citizen of India living abroad. In Section 19 of the Representation of People Act 1950 provides every person who is not less than 18 years on qualifying date of is ordinarily resident in the constituency shall be entitled to register as an electoral roll for that constituency. Representation of People Amendment Bill 2006, introduced on February 7, 2006 in Rajya Sabha, introduced a fresh bill, namely Representation of People Amendment Bill 2010 in August 2010 to amend Representation of People Act 1915 to provide that every citizen of India whose name is not included in the electoral roll and who has not acquired the citizenship of any other country and who is abstaining from his place of ordinary residence in India owing to his employment, education, otherwise outside India, whether temporarily or shall be entitled to have its name registered in the electoral roll in the constituency which his place of residence in India as mentioned in his passport is located, provide that electoral registration officer shall make correction of entries of electoral rolls and inclusions of names in the electoral rolls after proper verification, confer power upon the central government to specify after consulting the Election Commission of India by rules the time within which name of the person referred in the subparagraph above shall be registered in the electoral roll and the manner and the procedure for registering such person in the electoral roll. The central government has issued necessary notification bringing the act into force from February 2011. The Indian overseas can now furnish the documents self-attested by them and get their name enrolled in the electoral rolls for their representative constituencies. So this was justice and laws from the Indian summary book. The next topic is India and the world.